Hi, everybody. Sorry we're a couple minutes late getting started. We had a little bit of technical difficulty. So I'm Diane Yetter. Welcome to this live video to discuss the Wayfair case. We are actually broadcasting live from our Basics of Sales and Use Tax class. So that was interesting to be teaching this morning and have the case come down right in the middle of class. So things have been a little hectic. But we wanted to get online as soon as possible to talk with you all about what our initial feelings are and what the case said. We don't have all the answers. We probably don't have many answers yet, but what we're going to talk a little bit about is what we know today and what things we are going to be looking at and what things we think you need to be aware of as we look at this. So if you didn't hear, the decision was issued and authored by Justice Kennedy, who was the justice that made the comment in the Colorado direct marketing case that it was time for this issue to be decided. Hold on. Okay, we've got two computers in here and that just picked up. Sorry about that. And it was a 5-4 decision, which means 5 justices agreed with Justice Kennedy, and those were Justices Thomas Alito, Ginsburg, and Gorsuch. And the dissenters were the Chief Justice Roberts, Breyer, Sotomayor, and Kagan. And in their dissent, Chief Justice Robert wrote the dissent. I haven't read it yet, so I'm going by some briefs that I have seen. His dissent thought that that the court should defer to Congress on this. So that is what we're looking at. The decision was to overturn Quill, but not only overturn Quill, but also overturn National Bellis Hess, which is the case from 1967. So Justice Kennedy was quite outspoken and quite forceful in his comments. His overruling comment was the physical presence rule is unsound and incorrect, and therefore he said that Quill and National Bellis Hess are overturned. And some of the things that he focused on was that the physical presence test was giving the out-of-state sellers an unfair advantage over the in-state sellers who were required to collect the tax. He actually said Quill is flawed, and he also pointed out that the complete auto transit test, which is the case that came after National Bellis Hess that gave us the 4-prong test that said, you are, in order for a tax to be considered constitutional, there needs to be a substantial nexus with the state. And nowhere in that decision did it talk about physical presence. And that is one of the things that Justice Kennedy focused on in his decision. And he said that was not required. Something to remember is National Bellis Hess back in 1967 viewed both the Commerce Clause and the Due Process Clause as having the same threshold test for what constitutes presence. The Quill decision distinguished those and said that under the Commerce Clause, which is what is required before a state can make you collect the tax, you had to have that substantial physical presence. However, the Due Process Clause, which allows the states to require sellers to provide information to the state about their customers so that they can go and collect the tax from the customers, which is what has triggered the notice and reporting rules that we're seeing, that simply requires a minimal connection under the due process. So Quill made that distinction. The Wayfair case, this is going to now say, and what Justice Kennedy said is that these two basically should be looked at the same. And so we now have a reconvergence of the Due Process Clause and the Commerce Clause looking at this together. And so he said the due process threshold also applies to collection responsibilities. A couple of other interesting comments that Justice Kennedy put in there that led me to say at the beginning that this is what that this was a very harshly worded decision are things like Quill created a judicially created tax shelter opportunity for the sellers. So the phrase tax shelter has some very negative connotations. So that is a comment that he made. And he also said that Quill imposed arbitrary, formalistic distinctions that courts' modern Commerce Clause precedents disavow in favor of a case-by-case analysis, and also that the Quill physical presence rule is artificial, not just at its edges, which was a quote from the Quill decision, but in its entirety, and that the modern economy doesn't align with physical presence, and that the court should not maintain this rule that ignores the virtual connection to the state. So he really made a lot of comments, very forceful comments, that virtual presence and economic presence is really the way of the world today, and that the courts should not set some artificial boundaries on that. Another thing that we need to address is one of the points that came up in the oral arguments, and that is stare decisis. And basically, stare decisis is a concept that says if a court has ruled that you should, the court should not change it unless there is such an overriding change to things, that because businesses have relied on their prior decision, and we've been relying on the Quill decision for 26 years. And so what he said in regard to that was stare decisis can't support a court prohibition of a valid exercise of states' foreign power. And when something is that wrong due to changes in industry and in business, the court should correct their error. So he really has taken the position that the Quill decision was wrong, and he actually says that directly in the decision, which is interesting. He also addressed kind of what Chief Justice Roberts in his dissent is that Congress should take the responsibility of doing this. And what Justice Kennedy said, it is inconsistent with the court's role to ask Congress to address a false constitutional premise of this court's creation. So what he is saying is that the Quill decision set up a false constitutional premise, and therefore it was definitely within the Supreme Court's duty to go in and correct their decision. So that's some of what was said in the case by Justice Kennedy. Now let's talk about some of the specifics. So he did, and the decision, what it upholds is the South Dakota law. So if you read or heard any of the oral arguments, there was a lot of discussion about, and a question that was asked early on in the oral arguments as to what constitutes the appropriate threshold. And the South Dakota statute, if you're familiar with it, specifically says that that is a threshold of $100,000 of sales into the state or 200 transactions. And that's something that, if you read our blog post that I wrote, I believed that the court needed to rule on, not some lower threshold, but it's the South Dakota threshold that was being tested. The questions came up was in the oral arguments is one transaction sufficient? And both the South Dakota Attorney General and the Solicitor General of the U.S. said that one transaction was sufficient. And I disagreed with them taking that approach and thought that they should have focused on South Dakota. Luckily, Justice Kennedy did that. He focused on this and said that the South Dakota provision with that threshold, plus the fact that the law was stayed until the decision came down, made it that it could not be retroactive. And those were two of the points that were of concern in the oral arguments. And so the decision addresses and upholds the South Dakota provisions with the $100,000 sales or 200 transactions with no retroactivity. the other thing that Justice Kennedy talked about is that those provisions, those thresholds, give some protection to small sellers. And so that was another concern, that the burden on this would make it difficult for small sellers to comply. And he said that those thresholds do meet that ability to protect small sellers. So I know I've been rambling a little bit. I know Hannah, who is here with me, has said hello. We've recognized many of you are on here. We're very happy to have all of you here. And please feel free to post questions that you have it, and we will look at those and answer those as I go on. So please feel free to put any questions that you have. We love seeing everybody and saying hello. We see some of our clients up there, some of our friends, some of our partners. So thank you all for joining in on this. So let me see, let me go back to this. So another interesting thing that Justice Kennedy said is that physical presence is a poor proxy for compliance costs. And so this is where a lot of the concern about how much will compliance cost, you know, that it applies regardless of physical presence. And he actually used the example of a company that has one salesperson in the state. And, you know, that could even be just a transient. So somebody that goes in and does that just for a couple of days, excuse me, that would create a presence that would require them to collect the tax, and that could be a very small company that's doing that, but a large company that maybe has all of their sales force in a central location doing phone calls in, that will not create a collection responsibility. And so this physical presence being a poor proxy of when you have to comply and what your compliance costs, I think is a valid position to take. So we've had some questions come in, and what is the impact to other states? So we're still trying to figure some of that out, but here is what my initial interpretation is. If a state has passed a threshold that is the same threshold as South Dakota, so $100,000 in sales or 200 transactions or something higher. So we do have a couple states that have 250,000 or have 500,000 in sales as their threshold. The way I read this, those will be deemed constitutional and subject to tax. Now, is the threshold, if somebody has a lower threshold, would that be upheld? That, I think, is not 100% clear, but I think that has less likelihood of it being constitutional. The other question is the states that had nothing on the books, does this impact them? And we're going to have to look at each different state's law to determine whether or not their current definition of a retailer doing business, does it say specific activities? If those specific activities do not include some economic nexus provisions similar to this, then I do not believe that those would allow that state to impose a collection responsibility. However, if their statute says a retailer doing business as defined under the Constitution, then because this is a new interpretation of the Constitution, that would allow those states to impose a collection responsibility. So that's where we're reading it right now. What is not clear is the states that had laws similar to South Dakota's, that there were either stays in place because of the South Dakota legislation, or stays in place because they have their own litigation that is pending. Will those be able to be enforced retroactively? Because the South Dakota provision was prospective from the date of the decision, I think it may be difficult for those to be imposed retroactively, but I haven't looked specifically at those provisions yet in order to make that decision. So that's something that we're still going to figure out. Another couple of things to really maintain or keep in mind is this does not just apply to online sellers. This new rule is going to apply to everybody. So it will impact anybody selling into states where they do not have what I am going to call traditional nexus under a physical presence rule. So if you are a manufacturer and you are only located in 3 states and you're only collecting tax on sales into those 3 states, you now would have an obligation to collect tax on sales into any state that passes this sort of similar legislation. You're not selling online, you're maybe selling over the phone, you don't have a website, you're not a traditional what we call e-commerce seller, you would now have an obligation there. In terms of some of the other questions we're seeing is, will this apply to what will it mean for people that are selling things like software as a service or other digital goods, so not tangible goods? Again, you look at, and we talked about this in our basics class yesterday and today, when you're focusing on taxability or where you have a collection responsibility, you still have to, number one, figure out what is the transaction that you're talking about, what is the classification of the product. Then you look at where is the point of delivery, what state, what jurisdiction has the right to tax the transaction. Then you look and determine, do you have nexus in that jurisdiction? So this is answering that question. Let's just go under the presumption that now most companies are going to have nexus everywhere. And then you look at the taxability. So if today you have you're selling SaaS and you're selling it into California, and California does not tax SaaS, yes, you have nexus in California now, but your SaaS still is exempt from tax. But if you're selling SaaS into Texas, Texas taxes SaaS, so now you would have an obligation to collect tax on that. So you will have to still look at the taxability, and just because you have nexus doesn't mean you necessarily have a tax collection, because you have to look at what you're selling. If you're a manufacturer and you sell exclusively to retail or to other retailers who are going to resell your product, again, now you may not have a tax collection responsibility because it's still a sale for resale, but what it has done is it has made it more important for you to make sure you have all your resale certificates on hand. This could impact drop shipment transactions. We had that question come in. So now, the middle person, the retailer who is buying from a wholesaler that is doing the shipping, they may have a responsibility to now collect tax in all those states, but that middle person should now be able to issue a resale certificate from all the states, because they now would be required to be registered in all those states. So those are a couple things to keep in mind of some things that will change. We're having a lot of questions about what rate is going to apply. Keep in mind that in most states, the taxability, the tax authorities control all levels of the tax, all levels of the collection, so state, county, city, district. So you will likely have to collect all of those levels. In the home rule authority, so Colorado, Alabama, Louisiana, I believe that would mean that you would have collection responsibility in all of those localities too. However, keep in mind that a state like Colorado, that there is a distinction between a sales tax rate and a seller's use tax rate, that you may not have an obligation to collect all of the locals if you are selling from out of state in. So state administered localities in Colorado, for the most part, the county taxes are not applicable. So the only thing that would apply are some of the transit authorities and special purpose districts. So you may not have to collect all of those, but the home rule cities, I believe, but again, that's something that we need to dig into a little bit more. So there are lots of open questions. There were questions about who is going to be the collection agent. So somebody said, is eBay now going to have to collect tax for everybody, or will the marketplaces start collecting? So that kind of relates to, are the third-party sellers. So let's think about those marketplace providers. So third-party sellers who sell on a platform, a Walmart, a Amazon, an eBay, an Etsy, all of those sorts of platforms, except in a few states. Washington, Pennsylvania are the two that are the most prevalent right now, that have passed provisions that say that the collection responsibility is on the platform, on the marketplace facilitator, rather than on the third-party sellers. The other states put the collection responsibility on the individual seller, rather than on the platform provider. So we will have to see whether or not the states put in provisions that would change it and become similar to a Washington and Pennsylvania. I do not believe, under the state laws that I can think of right now, that the marketplace provider, because they are not deemed the seller, they are simply a facilitator, that they actually have the authority to collect the tax when the sale, the legal seller, is the third-party merchant. So that'll be something that we will dig into a little bit more on that. Let me think. So the case was also remanded to the South Dakota Supreme Court, and that was the first thing that we saw in terms of when the announcement came out, and we were like, wait a minute, what does that mean? So I've talked to a couple of other people, some other faculty that are here with me at the Sales Tax Institute class, and what we believe that remand is allowing is, originally I thought it was to validate the South Dakota threshold. After getting through the more of the case and talking to people, that is not what we believe. Rather, we believe because the case was very narrowly challenged under the constitutionality, under the physical presence challenge of Quill, and they didn't really address any other potential constitutional challenges, that the Supreme Court gave Wayfair and their co-defendants an opportunity to go back and raise another constitutional argument before the South Dakota courts. Obviously, we have no idea right now as to whether or not they will do that, but we will have to start thinking about that. Had a question, will this affect international sellers? My reading and interpretation is yes. So, and that could have impacted international sellers before today if they had physical presence in the States. Now, I think it is clearly just a straight economic test. If you exceed those thresholds, then you have a obligation. Lots of people are saying, well, what if do I have to start collecting today? Technically, in some of the states, yes. We're obviously trying to filter that out. What I can tell you in conversations that I had with Adam Krupp, the Commissioner of Indiana, and this is actually in our blog post, we interviewed him as part of our blog that you can see on our Sales Tax Institute website. He said that their law went into effect, it was effective July 1 of last year, that if South Dakota 1 technically, or theirs went into effect, they have litigation pending, so it stayed. So theirs would be, I believe he said it would be prospective as of the date of the decision, but he said they are not expecting taxpayers to start complying as of that date, nor do they plan to enforce it. He said that they were working on a plan. I have not had a chance to reach out to him to see if They have a date when they are going to do that. I'm hoping they're going to give some leeway. Some of the states, like Wyoming, I believe is one, and Vermont, I think is another, that they never put an effective date in. They said their effective date would be as of the date of a decision. So technically those states, it is today. I don't think any of them are realistically believe somebody today with the decision just coming down are going to be able to start complying. That is obviously something we're going to start reaching out to the states. We're going to start trying to find out exactly when that is going to be looked at and starting to be enforced. Mary made a comment, you still need to look to the state revenue statutes and regulations, absolutely, to find out if what you're selling is even taxable. So none of that has changed. You still look at the taxability of the products, you still look at the taxability of the transaction, you still look at the taxability of the purchaser to make sure what those are. A couple of people have said, what about a $1 one transaction threshold? My reading is that what the court has agreed to is you still need to have, and Justice Kennedy pointed out that complete auto still stands, which is our four-pronged test for what is deemed a constitutional law, a constitutional tax, and that requires substantial nexus with the transaction between the taxpayer and the jurisdiction. And so the way I'm reading the decision is that the $100,000 and $100,000 or 200 transactions is what they believe is a substantial nexus threshold. So I do not believe that they would uphold a $1 one transaction threshold. So I do think that is now the minimum rather than some much lower level. All right, so let me think. I know a lot of questions went by that I didn't catch all of them. So I am going to give me a second to scroll a little bit and see if I've caught everybody's questions. So I am, let me see, why are they not scrolling, Hannah? Hannah's peeking in here a little bit. Oh, she just got me how to do it. Okay. All right. So Hannah is a little bit more technologically advanced than I am. So let's see. So the question was, retroactive application wasn't really addressed other than South Dakota from what I viewed. What do you think will be done with regard to this for states other than South Dakota? I think that what the court said is that the South Dakota provision with no retroactivity is what they agreed made sense. So I do think we need to wait and see what some of the other states say. Do I think you need to get out and start doing voluntary disclosures quickly? I think it's something that, oops, hold on, Hannah, what did I do? I just lost my thing. Give us a minute, guys. Because I went really tiny that I can't. Hannah's going to pop in here. Hold on. This is technology. Sometimes it can be a little bit of a challenge when you're going live. And I don't even know what I did. All right. So hold on. There's Hannah. So those of you that read some of our stuff. But what we don't want to do is exit out because we don't want to lose what we're doing. So while she's trying to fix that, I'll continue talking about retroactivity. So I do think that that was one of the provisions of the case and the decision. The states that have the specific effective dates, I think that will be something that we will need to look at a little bit. We kind of got it back. There we go. Okay, sorry about that, guys. The home rule jurisdictions, we talked about that already. All right, Hannah, you may have to help me now with, oh, there it is. Okay. So are remote sellers now compelled to collect everywhere in these states? I think with the home rule, we talked about that. And the effective date we talked about. The implication of other states' pending legislation, I think we will have to look at how the state legislation was written, and that is something that we will start digging into this afternoon even, and look from there, which will also determine when we think companies have to start complying. When are non-collecting sellers expected to register in South Dakota? I am going to, we'll post something on that as we get a little bit more. Definition of remote seller. So in case people joined us a little late, because I think that was one of the early things I talked about, this provision applies to every kind of business, regardless of what you're doing. If you are a service business, but you also sell some things that are tangible, or if your services are subject to tax, keep in mind South Dakota taxes virtually everything, including professional services like accountants and lawyers. So now if you exceed the threshold into South Dakota, you would have a responsibility to collect tax there. So it is going to affect everybody that sells into the states. Do I think any states with current lower thresholds will change their statute to comply with South Dakota? I believe I went through this, and I think there's only one state that had 100,000 and 100 transactions. And so the question would be, will they change their law? We'll have to look at that. And I'm sorry, I don't remember which one that was off the top of my head. But I think when I went through this, everybody else was South Dakota or higher on that. Will eBay have to collect tax in all states? If eBay is the seller, then yes, but I believe on the eBay platform, they say that the third-party seller, the third-party posting on eBay is actually the seller. So I think you would look at each individual seller on eBay and do they exceed the threshold into any given state? And I think that's the other thing that you need to think about. Is the threshold is not, does the seller make $100,000 in sales or 200 transactions in total, but into each different state. So many small eBay sellers, individual consumers, not necessarily some of the commercial businesses that sell on eBay, but individual consumers, it is unlikely that any of them are hitting that threshold into any given state. But if you are a commercial business and you sell on eBay as one of your platforms, then because you're going to take into consideration all of your sales platforms, all of your different methods of making sales, that all of those in total, if you exceed the threshold, that is where you would have an obligation to collect tax on every way that you make a sale. So it's not just online sales. If you get phone, if you have in-person sales, that would now apply to all of those. Okay. Question, will this apply to gross receipts taxes as well? That's a good question. I think there is a likelihood that it would. Now, keep in mind that Washington, with their business and occupation tax, they passed a economic test a couple years ago that has been in effect. So they already had that. Ohio with their cat tax, that also that was challenged with the Crutchfield case. Last year, I believe, is when that came out. They had a $500,000 threshold. So I think that this very likely would apply to gross receipts taxes. Let's see, some of these questions I answered as they came over. Okay, so Monica Miles, a good friend of ours and fellow faculty member. Monica, thanks for giving me a quote from Justice Roberts' dissent. So she said, she found this: the court breezily disregards the cost that its decision will impose upon retailers. Correctly calculating and remitting sales taxes on all e-commerce sales will likely prove baffling for many retailers. Baffling indeed. And Monica's right. There are going to be challenges with this. Justice Kennedy actually made a comment about the software. He said there is software available, and that is true. He also said more software may become available. And he also said this is an area where Congress may legislate. So to me, when I look at the challenges with tax collection, the thing that I find most challenging is the inconsistent definitions and classification of products across the various different jurisdictions. And so I think that is an area that all of us should push the states, similar to what Streamline did, that we've got a common definition across the states that are streamlined participants. And by the way, that was another thing that Justice Kennedy pointed out, is that South Dakota is a streamlined state, so they do participate in these common definitions. But Streamline doesn't dictate how states tax things. It dictates how they define them. So a state can still define things separately or differently than other states, but they must define them the same way. And that, to me, is the biggest challenge with this. Being able to get the right tax rate based on the jurisdiction, you know, that's an easy problem, or a much easier problem to solve. It's the product mapping, the product classification, and then applying that classification to the state laws. And that's where I think all of us have our role now to go out and really push for some of that consistent definition and consistent classification across the different states. Let's see. So Brian made a comment, Nexus just got harder to determine, as now you will have to look at whether you are currently meeting the economic thresholds, and if not, track sales to determine if you meet them in the future. That's true. Truthfully, I think that's easier to track than it is today. Today, you have to track, where do your people go? You have to look at expense reports. You have to look at where somebody might have scheduled a trade show or put some inventory that you don't know about. Sales thresholds and number of invoice transactions, I think those are a little bit easier to track. And to me, it's a clearer, bright line than some of the tests that we have had up until today. Let's see. Chad, one of our clients, said, does this essentially mean we should be collecting as of today? Chad, I don't think we need to turn you on today, but I think we need to talk very quickly and figure out what we're going to do in regard to that. So I think we do need to move quicker on this. Okay, question. What if you are simply the e-commerce seller middleman who sells nationwide from a third-party manufacturer? Do you need to collect sales tax from all states? I think if you're talking about a drop shipment transaction, but you're the one that is invoicing the final customer, then yes, this is going to impact you. Janet said, we have Nexus in Florida and Indiana, but if we have small sales in other states, do we need to meet the 200 sales, 100,000 transactions before we have to collect tax in those states? Yes, that is the case. So if you make very little sales, so, you know, let's think of a brick and mortar retailer who has Nexus in their home state, and they occasionally have a customer come in and asks them to ship the product to their home because they're visiting, or as a gift to somebody else. So they have a couple of transactions that they're shipping into other states, and that's the only thing they have. They are not going to have to register in those other states until they meet that threshold. John asked the question, is that threshold per year, per quarter? It is a per year. Most of the states have said you look at the prior calendar year. Illinois, in their new provision, actually says you have to evaluate it quarterly, and every quarter you look at if in the prior 4 quarters you meet it. But most of the states, you look at the prior calendar year. Michael asked a good question. Is the 200 transaction minimum part only 200 taxable transactions or 200 total? My recollection in all the states for the economic nexus is both for the dollar threshold and the number of transactions, it is total, not taxable. So again, even under Nexus today, you could have Nexus, but if you make no taxable sales, you may not have an obligation to collect the tax. So Nexus is the first question. The second is, do you have an obligation because you make taxable sales? So you will still look at that. Sarah asked a great question. Is the transaction the entire invoice or each line? My interpretation, a transaction is an invoice, so not every transaction line. So that will make it a little bit better. Diane asks a great question. Is it an and or is it an or on the 100,000 and 200 transactions? Every state except one, to my recollection, and that is Connecticut, which just passed theirs in the last week. They are or tests. The Connecticut one is an and test, but everybody else is an or. Sarah, how and when is the threshold determined? When would the collection requirement kick in? My recollection on the way they write it is once you hit it. So I think the way states are looking at it, and we'll reread all of the legislation now that we know what is in there, is the you look at the prior year. So I believe what people are saying is this passed in 18, you would look at your activity in 17, and if you've passed that transaction, then you have it as of whenever we're going to determine the effective date is. But then I believe some of them say you have to look at it going forward. Alex just made a comment, it's an or. Maybe he's talking about Connecticut. So we'll relook at that. I thought I saw that was an and. How long, Jean asked, how long do I think it will take states with existing next economic laws to issue guidance post-Wayfair? I do believe most of them have been talking about this and what they're going to do. I would expect we will start hearing things very quickly for that. Oh, Hannah, your battery is going to die, so you need to get me power quickly. How is this going to impact small online starter businesses? If you are below the threshold, then you are not going to have a collection responsibility, but you're going to have to monitor your threshold. Drew, one of our partners, asked how many other states currently have a similar economic. We actually have a chart on our website, salestaxinstitute.com, that has all of those. I believe it didn't do it, Hannah. I'm still blinking. Is that not working? So I believe that it is, I think we're up to about 18 states that have that. You may have to put it directly in the wall. Can we do that? Or the wall might be dead. Hold on, guys. Hopefully we're not going to lose you. We lost it. This isn't working. Get me on here. Okay, hold on, guys. We're going to jump on another computer here real quick. It's must be a dead outlet. Okay, so I don't know. Okay, I don't know that we can switch computers. So you know what? This is a good time. We're at 45 minutes just about. We'll take a look at some of the other questions. Visit salestaxinstitute.com. Go to our resources and our helpful charts, and you'll see our remote seller chart. And we will be getting a lot more information out. Thanks everybody for joining us. And we will be posting this up on various different social channels, and we will go from there. So happy Wayfair Day, and thanks for being with us. Take care. Bye-bye.